Thank you, Mike. I want to go from the general to the specific, and I'm going to talk about arson in particular. You can extract the broad principles from the more particular detail. And I think a focus on arson makes sense for really two reasons. One is the case study we're going to leap into after this session focuses on an arson case, but there's a more important reason, and that is the much touted and extremely valuable NAS report really doesn't do much with the arson area except with respect to very old convictions. The NAS report is really a tool for post-conviction practice challenging very old arson cases. Why is that? Because in the 90s, the science of arson got cleaned up. And it got cleaned up with a technical resource called the National Fire Protection Association Guide for Fire and Explosion Investigations. This is copyright protected, so you don't have it in your materials. But what I did do in your booklets, you should find a handout, Resources on Arson Forensics, that I put together, and the NFPA 921 is front and center. What I've done as well is to print out the origin and development page as well as the table of contents. You will see it is your blueprint in an arson case. I'm not saying run out and buy it, but if you've got an arson, you must get it, okay? Now here's going to be the game in arson. So you're not going to be fighting about, crazy junk protocols. What you're going to be fighting about is application. It's going to be lousy work by the prosecutors, experts, so-called experts, applying principles they do not understand. That's the whole ballgame in arson. So what you're getting, I want you to go home, I think we all want you to go home with real hands-on, helpful stuff. Hopefully this helps you fill in a piece that the NAS report doesn't give you, which is arson. You'll go and there's a little thing saying there's not enough standardization, depth of char. A lot of that, you won't hear prosecution witnesses expounding about depth of char anymore. They know not to, because a lot of that is debunked in the NFPA 921. Do not think, however, that you're without ammunition in the post-921 era, because it's just amazing what witnesses will get up and say. And Marvin stole my thunder and told you a little bit about what Mr. Hebsche was treated to on his way to stacking double minimum mandatory sentences in a federal case, getting him 15 years. I want to talk about arson as not unique, but as special in another respect. And that is, you've got a challenge in arson as to whether or not a crime was committed. In many of the cases that we're talking about, that you've heard about, where you're dealing with fingerprints, the problem is who done it. It's linking the defendant to the crime. Arson is about, was there a crime? We know there was a fire, but was the fire the act of an intentional human agent? And here's the dirty reality of arson. It's not really about the forensics. It's about motive. And what does the prosecutor do? It lards up, the prosecution lards up the case with the motive, so that motive is now used to prove a scientific fact, which is cause and origin of the fire. I mean, to the point where I just read last week or the week before a little Superior Court case in Massachusetts where, are you ready for this? The prosecutor's witness actually said cause of fire undetermined. Jury came back guilty. Okay, so here's something I want you to go home with. I'm not saying this has ever worked anywhere. I would like to see it work. Move to bifurcate. Get motive out of the causation question. Move early to bifurcate. We're going to focus on cause and origin first. Now, this is assuming that cause and origin isn't truly obvious. And in most cases, it isn't. You've got a fully involved fire, where there's flashover or the building is destroyed. You've got a real cause and origin issue, and you should be, I urge you, move to bifurcate. At least get the judge educated. It's an opportunity to educate the judge that cause and origin should be treated as a separate question. Motive should not feed in to a scientific question. Okay. We're talking a lot about mindset. I want to underscore something because I came on Hebshe as post-conviction. And boy, I'm reading that transcript, and of course, the dog testimony was off the wall. But I couldn't tell that the firefighters in the fire marshal's office got it wrong. And what you have to do, I think, is constantly assume the scientific mantle yourself, that mantle of skepticism that the witnesses are not adopting. You must go in there and truly believe my client is innocent. There is a rational explanation for what happened here, and it's my job to figure out what the heck it was. You have to take the assumption that notwithstanding these glowing expertise and all of this background and all of these so-called lab reports, you have to assume that it's wrong. That has to be your so-called null hypothesis, a scientific notion in the area of inference. When are you justified in making a conclusion from a set of data? And so you must do that, and you must make sure that you maintain that mantle until, cause and origin is overwhelmingly determined to your satisfaction. All right. The real lesson of the Hebshe case in a sentence is you need to be challenging things pre-trial. What the holding of Judge Gertner in that case was, waiting and say, well, this will all shake out at trial. We'll do this at cross-examination. Not good enough. The home run is keep the evidence out. And don't think that your skills, are so wonderful that your cross-examination is going to destroy the witness. You want to keep the evidence out if you can. And if you cannot keep it out, the Daubert hearing transforms into an educate the gatekeeper, educate the judge into the limits of the testimony. This is where, even if you don't keep it out, and that should be job one. But job two is, what is this witness really able to say in the arson area? And you want to make sure, for example, I'm going to focus on arson, because you'll get testimony, the first-in firefighter, what did you see? And all of a sudden he's talking about, the fire is spreading from here to there, and I saw hot spots, and those hot spots meant, he's a firefighter. Stop. You have to make sure that the percipient witnesses, the first-in responding firefighters, aren't with the mantle, by the way, of their heroism and their bravery and all of that, now giving cause and origin evidence. And that will happen. In the Hebshe case, without objection, by the way. You need to be alert that percipient testimony is, I saw fire. I saw hot spots. That's it. Not what the hot spots mean, not how the fire spread, not where the fire started, etc. So I'm suggesting to you a Daubert hearing and a motion in limine are the places to begin with that. Okay. I don't want to go over all of the discovery issues again because Chris did such a phenomenal job on that, and I think Mike has underscored it. Let me say something thematically. You are, of course, assuming your client is innocent. And by the way, the data suggests arson is way over concluded. So in many cases, there really is no crime, and you need to assume that. So what does that really mean? That means you need to be thinking about, well, how the heck did this fire start? So it's not just debunking their experts, it's what is reality? What is the defense theory? And the defense theory isn't just, they did a crappy job. The defense theory has to be, this fire started this place and in this way. And I encourage you strongly to think in arson cases about developing the affirmative defense theory. The affirmative defense theory of how the fire started. And I did not include this because it's a general article, but I want to bring to your attention a piece I saw that came out, I think, in the NACDL called Building the Persuasive Case for Innocence. It really very nicely and much more elaborately makes this point. I suggest arson is a place where you want to really focus your discovery on building the persuasive case for innocence. So what I see as a mostly appellate lawyer is that it is very, very hard to overcome the practical presumption of wrongdoing if you sit on the presumption of innocence in an arson case where there's typically tons of motive evidence. I mean, the motive evidence we all have, by the way. Virtually anybody who's a homeowner can be framed into having tons of motive. You have an insurance policy. Who doesn't have debt? Who doesn't have kids in school? Who isn't strapped? So virtually any law-abiding citizen, the government can build a motive case. And opportunity? Well, it's your house. You have lots of opportunity. So that is, if you sit back, they will let the motive evidence do the work. And by the way, in the 2255 hearing in Hebshi, it was really shocking. Probably the most shocking thing in the whole hearing was to have defense counsel say on the stand, with Judge Gertner sitting right there, that what sunk Jimmy Hebshi was not the forensics, but the motive evidence. There was a collective, gasp. This was a defense lawyer who really did not, he fell into the same trap we're trying to avoid the jury falling into, which is he believed the motive evidence was enough. In fact, it was paltry. That's how persuasively the government had framed the motive evidence, that even the defense counsel believed in a case where it was just absurd. So don't get blinded by that yourself. So the biggest task in an arson case is to figure out who's got what. The government in a typical arson where there's real damage really is not the only repository of the evidence. Who else? There will be insurers, and probably more than one in a commercial building. In a commercial building, you will have tenants who have occupancy policies, and you will have the building owner who has the overriding policy. What will happen is, and here you talk about expectation bias and context bias, what you will have is the fire marshal calling up the building's insurer and saying, we think it's suspicious. I swear that they actually do that. They pollute the pool from the get-go. What will then happen is the state will release the scene, the investigators for the private insurers will go in, they will redo the investigation, but they've already been pointed in the right direction, sometimes literally told where the state has come up with cause and origin. So what you really need to do to show the bias is to get those running notes, those business records from the private insurers. They will also have taken photographs. They will have taken often many more and better documented photographs than the state will have. This is incredibly important because it may give you more information about what was impassable, what the condition of the premises were, what it was at the time that a dog was deployed, et cetera, et cetera. So that is very, very important. And if you can't get through getting the government to do it, then you need to file a request. I would submit, if you could try to do it under seal, to get them subpoenaed before a hearing. You should do that. If you have to share it with the prosecution, it's still better to get it than not. Another bit of practical advice I want to give you, because none of us is a scientist, or very few of us is a scientist, then what we really need to do, and early on, get yourself a work product expert, at least one. I would suggest one at first, and that is a person who can tell you what you don't have, what's missing, who else you need. They can truly help you build your team. And I see some quizzical looks. If you've got questions, go ahead and ask. But I think it's essential. And veering off from arson a little bit, I would say, I want to make a pitch because I may not have another forum to do this. This is a more general application. It's often very, very helpful to hire a forensic statistician, a person whose business it is, whose profession it is, to figure out what can we really infer from the data. I mean, that's what they do. And they may do that better than a chemist or a biologist. I mean, in fact, there are arms of almost all the natural sciences and the applied sciences that import statisticians to help them with design of experiments, inference, hypothesis testing, calculation of confidence intervals, etc. In other words, you have to see statistics as the queen of the sciences. It is the science that allows the other disciplines to figure out what is it they really know. It's really epistemological. What do we know from this information? I used it, believe it or not, in a fraud case. I got a graduate student to help me look through a data analysis in a fraud case, and she saved the client $100,000 in restitution. I mean, she halved it. I was hoping she was going to tell me you couldn't make the inference they had done, but what she did say was, the numbers are way, way, way off. And I was able to show that, the prosecutor was backed right off, amazingly backed right off, because she wasn't on top. She hadn't hired a statistician. She wasn't going to be able to counter that. So that's an ace in the hole. I've never heard anybody talk about that. I'm a big proponent. You can get it cheaply, and it's very helpful. But in any event, in an arson at least, you want to get a fire protection engineer. You need this fire protection engineer to tell you whether you need a chemist, et cetera, et cetera. I have written out like a whole bunch of things, specific questions. It may be that it's better to do that in the other session because I think we may be running up against time. And every fire is going to be different, and your attack is going to be different in every case. And it may be helpful to do that more when you're faced with the specific facts that we're going to be dealing with. I want to say something else in the arson area. Every arson investigator who works for the state and for the insurance companies is certified by the International Association of Arson Investigators. They all are. And then you start probing their background. And how is it they're trained? And how is it they're tested? And it's ridiculous. It truly is ridiculous. And yet, amazingly, I found in the Hebshe case, for example, they destroyed the defense expert on qualifications because it's not his job to determine cause and origin. He's a fire protection engineer. He actually knows something about fire dynamics and physics. He isn't hired by an insurance company to say that this is an arson so we don't have to pay. He isn't an ATF agent who gets a stat for an arrest and an indictment. Never mind. They don't get stats for convictions, by the way. They get stats for arrests and indictments. They will try to make mincemeat of your real expert. And I'm happy to tell you, this is your little guy, this is your ace in the hole, because it talks about the real qualifications. And it says, arson investigators, you may need a fire protection engineer. You may need a chemist. You may need the kind of people that you're going to hire who are going to be real scientists and technicians, et cetera. The other thing I want to say is, we've been talking a lot about science versus applied science, and I want to take issue, or I want to at least drop a footnote, I think an important footnote. Don't forget Kumho Tire. Kumho Tire tells you Daubert applies to technology. It doesn't just apply to science. So it has to be peer-reviewed. All of those protections, peer-reviewed, the assumptions have to be clear, blah, 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 blah. Those apply just as much in an applied science or a technology as they do in a what we would call a pure science of chemistry, physics, etc. And then my final point, because is this it? Am I running out of time? I'm so confused now on the time. But anyway, the last point I want to make is, we've been talking a lot about error rates, and subjectivity and objectivity. I just want to remind you, some things, in fact, are not subject to error rates. The laws of mathematics, the laws of physics, chemistry. These are hard sciences. There are determinable answers. When we're talking about error, we're talking about inference, we're talking about measurement, we're talking about observation error, we're talking about bias. But if you have something, distinguish between, I tested this thing, and I tested it 10 times, and I came up with 10 different numbers, and now I have to figure out, what's the most likely real number that blood alcohol level was, and what's the confidence interval, and how much is the error. That's a very different thing from, can fire start here and get over there? Okay? That's physics. Now, they may not have done an investigation that is sufficient to allow them to know the answer. In which case, why is the jury hearing it at all? Okay, why are they hearing that? This isn't about opinion. This is about, you don't know. You don't know because you don't have enough information to know. And that is, I don't know if I'm being clear with you about this, but some things aren't a matter of opinion. And what you either have is enough data or not enough data. Gatekeeper. That's what Daubert is for. Keep out surmisal. Keep out, mere speculation. And that you're going to see in the arson area, where they don't know. And they can't know because there isn't enough information and there isn't a way to get it. Thank you.